Welcome back to the channel and to another deep dive. Today, we are getting into something truly foundational, something you might even call the very architecture of justice.
It really is. We're looking at historical sources on the governance of Hazrat Umar ibn al-Khattab, specifically around the year 16 AH. That's about 637 CE.
Right, and our mission for this deep dive is to understand the standardization of court procedure. We're going beyond just having, good laws or honest judges. We're looking at the structure that makes it all work.
And that's the core question, isn't it? It's a classic paradox. You can have honest judges, you can have strong laws rooted in divine principles, but the society can still suffer from profound injustice. The question is, why?
And the answer is procedure, or I guess a lack of consistent procedure.
Exactly. If the way you file a case in one city or the standard for evidence in another is completely different, the whole system just falls apart.
It becomes a lottery, right? The sources use that exact word. People start to feel like justice just depends on where you live.
Or who you know. That power matters more than proof. And once that belief sets in, public faith in the entire system just pressure. It evaporates.
So this is where our deep dive, based on Case 12 from 16 AH, really begins. This is the moment when Hazrat Umar confronts this problem head on. He doesn't just, send out better judges.
No, he architects a system. He creates a unified institutional model for the entire empire.
And this is the central idea for today, the real insight he brought to the table. Justice isn't just about getting the right outcome. Justice is also a correct process.
That's the leap. It makes the how just as important as the what. The predictability of the process is what gives the outcome its legitimacy.
Okay, so here's our roadmap. First, we're going to unpack the four big constitutional threats that this rapid expansion was creating.
The why behind the reform.
Exactly. Then we'll get into the details, the 6 specific domains of procedure that he standardized. This is where we see what predictability actually looked like.
And finally, we'll look at the political genius of it, how these rules became a shield for judges, protecting them from outside pressure.
Let's jump in.
Okay, so to really get why this was so urgent, you have to picture the situation in 16 AH. The state is expanding at an unbelievable rate.
Right. And this isn't just about more land. It's about new cultures, new economies, new people.
Totally. And the courts are on the front line of that complexity. Suddenly, a judge in a new city like Kufa isn't just dealing with local disputes he understands.
He's dealing with what? Different religions?
Different religions, which had their own internal laws, new, really complex economic disputes, maritime contracts, long-distance trade, things that were just new.
And different local customs that might clash with the state's laws.
Wildly different customs. On top of that, you have judges who, they're good, honest men, but they all have their own personal temperament, their own ideas about what makes for good evidence.
So if every judge is kind of making up the rules of his own courtroom as he goes, the whole thing is just a mess.
It's more than a mess. It's a constitutional crisis waiting to happen. An expanding empire becomes an expanding set of legal contradictions, and the sources point to 4 specific threats this created.
Okay, let's take them one by one. What was threat number 1?
The most obvious one: unequal justice. Plain and simple. You have 2 identical cases, say a debt dispute, one filed in Syria and one in Egypt.
And they get completely different results.
Wildly different. Maybe the judge in Egypt demands 2 eyewitnesses to the contract being signed, and he cross-examines them for an hour.
Okay.
Meanwhile, the judge in Syria just looks at a stamped piece of paper, asks for a quick oath, and that's that.
So the public sees this, and what do they think?
They think justice is arbitrary. They think the law isn't universal. It shatters the idea of a single unified state under one set of principles.
And that leads directly into the second threat, doesn't it? Forum shopping.
Oh, absolutely. This is maybe the most dangerous one for the integrity of the system.
So just to be clear for everyone, forum shopping is when you choose your court based on where you think you'll get the best deal, not where the case actually belongs.
Precisely. You're gaming the system. Imagine you're a merchant. You know Judge A is really strict about documents, but Judge B is a bit more lenient and relies on verbal testimony.
And your documents are a little shaky, but you have friends who will testify for you.
There you go. So you find a way to file your case in Judge B's court, even if it's miles away from where the dispute happened. The search for justice becomes a game of strategy.
It rewards manipulation, not honesty.
Completely. And it makes knowledge of legal loopholes more valuable than the actual merits of your case.
Okay, what's the third threat? This one sounds a bit more political.
It is. It's provincial legal autonomy turning into fragmentation.
Meaning?
Meaning, when the court procedures are vague and informal, it creates a power vacuum. And who steps into that vacuum?
The local governor, the powerful tribal leader.
Exactly. If there are no clear written rules from the central government about how a trial must be run, the judge is left vulnerable. The local governor can just nudge him.
He doesn't have to break the law. He just has to influence the unwritten process. Hear my friend's case first. Or don't look too closely at that witness.
And suddenly the law isn't an instrument of the state anymore. It's a tool of local politics. Standardization removes that ambiguity. It gives the judge a rule book he can point to.
A rulebook that comes from the caliph himself.
Which is a very powerful defense. And all this culminates in the fourth threat, loss of state legitimacy.
Which is the end result of all the others.
It's the inevitable outcome. If the public sees this system as inconsistent, negotiable, and subjective, they lose trust. Not just in the courts, but in the entire state.
Because the courts are where most people actually interact with the state's power.
It's their most direct experience of governance. So Umar's insight here was, it was revolutionary. He understood that a unified state must have unified judicial procedures.
It's not about crushing local culture. It's about making the court process predictable.
Utterly predictable. So that a citizen anywhere in this vast, sprawling empire knows exactly what to expect when they walk into a courtroom. That predictability is the glue that holds it all together.
Okay, so the need for this reform is crystal clear. Let's get into the specifics, the how. How did this actually work on the ground?
Well, this is where you see the shift from, a chaotic, personalized approach to a disciplined, institutional one. And it happened across 6 key areas or domains.
Let's start with the first one, court conduct and formality. This sounds almost superficial, but I get the sense it wasn't.
Not at all. It was psychologically essential. This was about establishing the environment of justice. The sources are meticulous about it. Things like where the judge sits, the decorum of the room, and crucially,
the equal treatment of everyone present.
Yes, the mandate for equal seating and treatment for all parties. Think about what that means. In most societies at the time, your social status was physically visible everywhere.
So a rich man would get a chair, and a poor man would have to stand.
Exactly. And the judge might address the rich man with respect and the poor man dismissively. Umar's procedure explicitly outlawed that inside the courtroom.
So the procedure itself forced equality into the room.
It made equality visible, tangible. The judge had to use the same tone, give the same amount of time to a governor as he did to a farmer. It was a radical idea put into practice.
Okay, that makes sense. Let's move to domain 2, filing and hearing. This seems to be about tackling the chaos.
It is. It mandated clear scheduling, no more hearings whenever the judge feels like it or whenever a powerful person gets his ear. A disciplined court calendar.
And a huge rule here that the sources emphasize, no secret hearings.
Absolutely foundational. Justice has to be seen to be done. Secret hearings are where corruption and backroom deals happen. Making them public and transparent was the antidote.
It also says all parties must be heard properly, so a judge couldn't just cut someone off.
No. He couldn't just read a file and make a decision. The procedure required him to give both the claimant and the defendant adequate, defined time to make their case. It forced him to listen.
Okay, on to domain 3, evidence management. This feels like the heart of the matter.
It's where the intellectual rigor comes in. The procedure demanded rigorous witness scrutiny. It wasn't enough to just have 2 witnesses.
You had to check them out.
The judge was required to investigate their character, their reputation for honesty, any potential biases. We're talking about a formal process for verifying credibility.
And what about documents? With trade booming, that must have been a huge issue.
A massive issue. Forgery was a real threat. So the procedures laid out formal steps for verifying documents, checking the seals, confirming the witnesses on the contract, making sure it was in the right format. It was about creating a consistent standard of proof.
Which leads us to domain 4, the burden of proof.
This is a big one.
This is the bedrock. The procedure answered that fundamental question. Who has to prove what? And the rule was crystal clear. The claimant proves the case. And if they can't...
And the denial of the other party, the defendant, is accepted under oath.
Why is that so important? It seems simple.
Think about the alternative. If you had to prove your innocence every time someone accused you of something.
The courts would be flooded with baseless claims. It would be chaos.
Complete anarchy. This rule creates a firewall. It establishes a presumption against baseless accusations. It protects ordinary people from malicious lawsuits and lets the courts focus on serious claims that have actual evidence.
Okay, domain 5 is record keeping. The administrative backbone, as the outline calls it. Sounds a bit boring, but I'm guessing it's vital.
It's what makes the system permanent. Before this, a judgment was just something the judge said, an event. Standardization demanded that written records of all decisions must be kept.
So you have a paper trail.
You have a paper trail, you have accountability, and you have institutional memory. The records included not just the final verdict, but also summaries of the testimony.
So a decade later, another judge could see how a similar case was handled.
Exactly. It creates consistency over time, not just across geography. It gives this system a memory.
And finally, domain 6, enforcement. A judgment is useless if it's not enforced.
It's just a piece of paper. The procedure had to include a standardized, state-backed process for making sure the verdict was carried out.
And it also protected the winner of the case.
Yes, protection against retaliatory obstruction. It ensured that the losing party couldn't just use their power or influence to delay or ignore the court's decision. The verdict was final, and the state's power was behind it.
So when you put all 6 of these together,
You move from a system based on one man's personal judgment to a system based on institutional discipline. A court is no longer just a person, it's a process. And that distinction is everything, the functional difference between an event and an institution.
right, an event it's a gathering. A dispute happens, people come to a judge, he makes a ruling, everyone goes home. It's temporary.
And its authority is tied completely to that one person, to his wisdom, his piety, his personal reputation. If that judge is flawed, the entire system in that town is flawed.
So it's incredibly fragile.
Utterly fragile. Umar's reforms were a direct attack on that fragility. By making courts hold regular sessions, by forcing them to follow a set order of business, he made them stable, permanent.
An institution. The new judge who comes in 5 years later doesn't have to reinvent the wheel.
He steps into a pre-existing framework. The rules are already there. The records are already there. The court's authority now rests in the rules of the institution, not the personality of the man in charge.
It's such a modern concept, building systems that are stronger than the individuals who run them.
It is the essence of good governance. The institution protects the people, even from the potential failings of its own officers.
I want to circle back to something you said earlier about the institutionalization of equality. That this wasn't just an ideal, but something baked into the procedure.
Yes, and this shows such a deep understanding of human psychology. It wasn't enough to just say, everyone is equal before the law. The procedure had to make that equality visible.
The same tone of voice, the same amount of time to speak.
The same physical treatment in the courtroom. Because he understood a fundamental truth about public trust.
Which is what?
If people see unequal treatment in the process, they will automatically assume the judgment is also unequal. It doesn't matter if the final verdict is legally perfect.
The perception of unfairness taints the whole thing.
It destroys it. So the procedure was designed to make fairness visible, to make it undeniable. It was a constant external check against the natural human tendency towards bias. He was essentially institutionalizing impartiality itself.
So we've covered how this made the system fair and efficient. But there's a political layer here that's just brilliant. This wasn't just good administration, it was a strategic move to protect the judiciary.
Oh, absolutely. This is about the separation of powers in practice. In a huge, sprawling empire, what's the biggest threat to a local judge?
The local governor, the powerful military commander, someone with real political muscle.
Exactly. And when the rules of the court are vague, unwritten, informal, that judge is a sitting duck.
It's so easy for the governor to apply pressure, not even directly maybe.
Subtly. He doesn't have to say, rule in my favor. He can say, you know, this case my friend is involved in is very important. Perhaps it should be heard sooner. Or, that witness against my ally, I've heard he's not very reliable.
And if there are no written rules, the judge has nothing to fall back on except his own personal courage.
Which is a lot to ask. So this is where the procedure becomes a shield. Once the rules are written down, uniform, and mandated by the caliph, the entire dynamic changes.
How so?
Well, let's take that example. The governor comes to the judge and says, fast track my friend's case. Before, the judge would have to personally defy the governor.
A political risk.
A huge risk. But now, with standardized procedure, two things happen. First, any interference is now obvious. It's a visible violation of a known rule. The court clerk sees it. The litigants see it. It can be reported.
The pressure can't happen in the shadows anymore.
Right. And second, and this is the key, the judge now has the perfect defense. He doesn't have to say, no, I won't do that.
He can say.
He can say, this is the process mandated by the central authority. No one can alter it. Not me, not you.
So he's not being defiant. He's being obedient to a higher authority.
Exactly. He uses the rule of law to defend himself against arbitrary power. It's a genius move that embeds judicial independence directly into the administrative DNA of the state.
But this brings up a potential problem. Does this make the system too rigid, too mechanical? Does it take away the judge's ability to be merciful or to consider the unique facts of a case?
A critical question, and the answer is no. The sources are clear on this. The standardization applied to the process, not necessarily the outcome.
So the path to the decision was fixed, but the decision itself wasn't predetermined.
Precisely. The judge still had to use his wisdom. He retained flexibility in interpreting the facts. He had to consider the specific context of the dispute. The procedure ensured he got all the information in a fair and orderly way.
But it didn't tell him what to think about that information.
Exactly right. So it struck this incredible balance. It prevented chaos, which is what you have with no procedure, but it also prevented tyranny, which is what you get when the law is so rigid it can't adapt to human reality. So when you step back and look at the big picture, you see that this wasn't just a legal reform, it was a civilizational stabilizer.
Right. The benefits went way beyond just having better court cases. You can see how it would affect the entire society.
Well, think about it. First, you get a massive boost in public confidence and trust. People believe the system works. That fosters loyalty.
And it must reduce violence, right? If you know you can get a fair hearing in court, you don't need to take matters into your own hands.
It channels conflict into a peaceful, predictable process. But the third benefit is maybe the most important for an expanding empire: economic stability.
Commerce.
Commerce. No sophisticated economy can grow in a state of legal chaos. Why would a merchant in Iraq enter into a big contract with someone in Egypt if he thinks a dispute will be settled by the whim of some local official?
He wouldn't. The risk is too high.
But if he knows the rules for contracts, for evidence, for enforcement are the same everywhere, he'll take that risk. He'll invest. He'll trade. Predictable law is the bedrock of a prosperous economy.
So it all comes down to that core belief. If I am wronged, I can go to court and the court will work.
That shared belief is what turns a collection of territories into a unified civilization.
And it's amazing how much these reforms from the 7th century sound like the foundations of modern legal systems.
They are absolute prototypes. Look at any modern state. What does it have? It has a civil procedure code, a criminal procedure code. It has an evidence act. It has detailed court rules.
All things designed to do exactly what we've been talking about. Standardize the process.
To remove inconsistency, to fight bias, to ensure accountability. Umar ibn al-Khattab was, in essence, engineering the software for an empire-wide judicial civilization, and the principles are timeless.
So what are the big takeaways for us today, the lessons from this?
I think they are incredibly relevant. So many places in the world still suffer from different justices in different districts, from informal influence and procedural chaos.
So what would the sources tell us? What are the key lessons?
I'd say there are four. The first is that procedure is not bureaucracy. It is justice itself. It's the tangible guarantee of fairness.
Okay, number 2.
Uniform rules actively reduce corruption. Ambiguity is where corruption lives. Clear written rules are like sunlight. They disinfect the system.
3rd.
Predictability builds trust and stability. It's true for the economy. It's true for social peace. People need to know the rules of the game won't change tomorrow.
And the last one.
Courts must operate like institutions, not personalities. The system has to be strong enough to work even when the people in it are flawed. The rules have to be stronger than the rulers.
Well, that brings our deep dive to a close. It really is incredible to think about how these foundational challenges of governance, consistency, predictability, protecting justice from power were tackled with such foresight so early on.
He was building an institution meant to last for centuries, not just for his own lifetime.
I love the analogy in the outline that he built the judiciary like an architect builds a bridge. It's not for one person. It's for millions to cross safely, knowing the structure is sound.
And by standardizing procedure, he made sure that what mattered wasn't your tribe or your wealth or where you were from.
All that mattered was the law, the evidence, and the process. That's what constitutional governance is all about.
A profound achievement. It shows how administrative discipline can be a direct path to liberty and public trust.
So a final thought for you, our listener, to take away. Look at the institutions you rely on in your own life, whether it's government, your workplace, anything. Which of them feel durable and trustworthy because their procedures are clear, written down, and followed by everyone?
and which ones feel fragile, vulnerable to politics or personalities because the process is informal and depends entirely on who is in charge that day.
It makes you realize that procedure isn't just a detail, it's everything.
It really is.
It certainly does. Next time on the deep dive, we're going one level deeper. We've talked about the how of the court. Now we're going to get into the what's of the evidence. Our topic will be evidence and testimony standards, case 13, who can testify, and how truth is verified.
The perfect next step. You've built the structure, now you have to make sure what you put inside it is sound.
Join us then for the next deep dive.